The next panel of speakers is the perspective of the employer carrier bar. And we have a special introduction of our moderator by the Honorable Brian Anthony. Thank you.
Good morning, everybody. Can y'all hear me back there? Yes? Okay. I didn't hear you when you said yes. You know, I don't know why that they bring such a special person to come and moderate this case, but they asked me to go ahead and specifically introduce Judge Moneyham, and I guess it was because of his background. There's a couple things about the judge you all don't know, and you might want to take some notes because this may help you when you appear in front of him.
You weren't supposed to say this.
He's got a long, distinguished background in the performing arts. He has been one of the top performers on Broadway for the last 15 years. However, he decided to transfer into this field, and he's been, from my understanding, he was a heck of a trial attorney and an appellate attorney before he got this position. And again, because he needed a special introduction, I think we should all put our hands together for one of the top 30 workers' compensation judges in the state, John Moneyham.
Well, in a state of 23 million, I think that's pretty good, top 30. Can't argue with that. We got a great panel here today. I remember when I was an EC attorney, the height of technology was a fax machine and a cordless phone. Somebody call you up and say, I'm walking around in my yard. Can you believe it? That's incredible. But anyway, we've got a great panel. These aren't emerging leaders. These are already leaders in the field, and they will be for years to come. And that's great. And that's great news for the profession. We got Dan Jaffe with the Richmond firm, Mariam with MKRS, Andy Borah with HR Law, and then Beyl with the McConaughey firm. And they're all partners there. They all give back to the workers' comp community, just excellent attorneys, and I've enjoyed working with them. All right, we're going to talk about rising out of first, and this was a topic assigned to Mr. Jaffe and Ms. Giannis. And Mr. Jaffe, bring us up to date on the state of the law regarding the rising out of.
Well, thank you, Judge. You know, I heard the claimant's lawyer speak earlier today, and I heard some things that I didn't agree with, of course. That's the nature of what we do. You know, from a defense perspective, the law has undergone significant change over the years. You know, we started off with Caputo and Walker and Ross and Urbina. And, you know, those cases, in my opinion, really changed the law, because what happened in those cases essentially was that defense lawyers went in and they thought that they didn't have to prove that the accident didn't arise out of employment, and they ultimately lost because the first DCA ruled that they did have the burden to establish that it didn't arise from the claimant's employment. And I always thought that it was the claimant's burden to prove arising out of. And so what those cases essentially said was that once the claimant was in the course and scope of employment, then the accident did arise out of employment. And I thought that was a departure. And then, of course, we have the Valcourt-Williams case, and the First District said that Valcourt was in the course and scope of her employment. There was no evidence as to major contributing costs, so why didn't that claimant have the same benefit of the doubt like Caputo and Ross and Urbina, and ultimately, of course, we know what happened with Valcourt. And then we have Silberberg, which really kind of broke the tie between and among those various cases. And I think that really is the state of the law as we sit here today, you know, kind of moving forward. And, you know, Silberberg really stands for the proposition that when there is no pre-existing condition and the accident happens in the course and scope of employment, all the claimant has to do is show some level of exertion that is connected to the employment for that to be a compensable claim. And they specifically reference in the opinion that walking is enough. So that's the state of the law when there's no pre-existing condition. But when there is a pre-existing condition, then the burden is that the claimant's lawyer has to show that the employment created an increased risk, an increased hazard to show compensability. So, Judge, I think that's where we are now, post Silberberg.
All right. And sticking with you, Mr. Jaffe, how is arising out of employment defined, and how does it differ from course and scope of employment?
So, course and scope is time and space. Are you where you're supposed to be at the time that this thing happens? Are you on the employer's premises? That's a fairly easy determination, although that's a whole nother topic for another day. Arising out of really is workplace causation. And I heard the claimant's lawyers talking about that they now have to prove fault. And I just don't agree that that's the nature of what arising out of is. There has to be some level of a causal connection between the work and the accident. There has to be a link to the employment. I don't think that's quite fault. I think that is a separate component from fault, and frankly, I don't think that's a new thing. I think that's been in existence for the last several decades. Exactly how you get to it may have changed a little bit with the exertion test versus the increased hazard, but I think that's the distinction, Judge.
All right, thank you. And we'll go off script. I want to ask Ms. Giannis a question that we hadn't talked about. It's the most difficult question in all of comp. Do you spell adjuster with an O or an E?
Depends on who you're talking to.
We'll leave that question to the claimants attorneys and panel. Their vocabulary appears to be a little broader than the EC attorneys. So. All right. Ms. Giannis, is the fact that an accident occurred in the workplace enough alone to meet the arising out of standard?
No, I think that's the easy answer is no. I think, as indicated by Mr. Jaffe, it's not that the accident occurred at work. I mean, I think just the 440 doesn't cover workplace injuries, it covers work-caused injuries. And I believe the Hamlin case did codify that and remind us that, and to go with what Mr. Jaffe said, this has been pretty long-standing. The 1940, the FID versus Cass case actually says you do need some causal connection to the workplace and the ultimate injury. So just being there at that time is insufficient. You do need to prove that the ultimate injury suffered is somehow causally connected to the work that you're performing.
All right. And Mr. Jaffe, who has the burden to prove that an accident arose out of employment?
You know, Judge, if you had asked me that question after Caputo and Walker and Ross, I may have answered this question differently, and I would have said it depends upon what the nature of the evidence is. And to a certain degree, I think that that is still the answer, although I think certainly the claimant has the initial burden. But of course, from a defense perspective, it's not so easy for us to sit on our hands and rely on the claimant lawyer to not do his or her job. The people that were up here today, clearly very competent. Everybody in the room is very competent that does claimant's work. I don't feel comfortable relying on a claimant lawyer to not do their job. And so ultimately, when we are presenting our evidence, we may as well be assuming that it is our burden to prove it as well. I think that you have an obligation when there is a test involving increased hazard to potentially establish that there was no increased hazard, even though I think that is the claimant's initial burden. I also think that if the standard is going to be any level of exertion, for me to potentially establish that the accident and the injury was idiopathic in nature and it didn't come about from that exertion that they're trying to link to the workplace. So I think it's the claimant's burden, but that doesn't relieve the defense burden of establishing what I think really happened and therefore arguing that it didn't arise out of employment. So how the judge ultimately handles that distinction, I think, is, the creative art of order writing. But to a certain extent, my view is that we need to be prepared to argue all facets of that in the event that the claimant lawyer actually does meet their initial standard, Judge.
All right, thank you. And we're going to get to Mr. Borah and Ms. Beyl. They're doing the 120-day rule. They're the experts on that. We're not saving them for money time in the fourth quarter. So if they got anything to add, they certainly can as well. Anybody wants to add anything to these? But I know that Mr. Jaffe touched on the any exertion test. Do you want to add anything about that, Ms. Giannis?
Yeah, so likewise, I heard claimant's bar this morning, and they talked about any exertion. So they just said before, we used to say if you just tie your shoelaces or you hurt yourself while doing that, or you tripped over your shoelaces, that's sufficient. And I think when you deal with the any exertion or the exertion test, it's really when there's no other competing cause, right? You have nothing pre-existing, there's nothing else, so therefore, because we can't prove anything else, then thereby it's a compensable claim. I think defense attorneys, I would agree, have a bigger challenge in trying to find that pre-existing condition, in trying to find the other cause. Because if the defense attorneys don't do anything, well, it's any exertion, there's nothing else, and it's compensable. So we're charged with the responsibility to defend our clients, and in doing so, you have to engage in that discovery. And with a short time frame, with a short docket, I would put out that actually defense has a more difficult task in front of them in actually securing that evidence, because, and I may be jumping a little bit out of order, but I think it kind of flows with it, which is we don't get the case immediately. You as a claimant's attorney have it for a long time. By the time defense gets it, we may be further down than what we have. We have to secure the records. We have to now depose the claimant. And at least, I'm in South Florida. You get a claim, I call immediately the first day. I'm not getting a depo until 3 months down the line. The claimant, oh, we can't sit, we have another event, depo is suspended, I'll get you one in 30 days. And now you're eating 60 days out of a time that's still ticking, and I need to get medical records. I need to get doctor's depo. I need to do, for my client, what I need to do, which is to prove that there is another cause. Otherwise, you have the body of case law that says if there's no other pre-existing or competing cause, the workplace accident will be the cause.
Judge, if I may, I agree with Dan in that I don't think that while the rising out of standard may be a little different in the way we view it, it's really the same thing. And I don't think fault comes into play. And there's a recent case that came after Silverberg called the Sawyer case. And they had a line in that statement, in that case, that said, clumsiness is covered. And so I think that says it all. And so if clumsiness is due to no fault of the employer, it's due to the fault of the employee, and that is covered. And so I really, even though there has been some cases, like the Valcourt-Williams case that dealt with an extreme situation as a tripping over a dog at home, and then there's the Bouillard case that dealt with an assault. But this general, run-of-the-mill cases, I think that fault does not come into play, and the Silverberg case and then the Sawyer case reinforce that.
All right, thank you. And Mr. Jaffe, you want to add anything about the increased hazard test?
Increased hazard, we see it in various parts of the law, right? To a certain degree, you see it with course and scope when there's a special hazard that you accompany on the way to work. You also see the increased hazard when it involves a secondary injury, right? So you get hurt or you have a condition, a seizure disorder, and you fall. And the question is whether the injury from the fall is related. And they talk about the increased hazard with regard to the secondary injury. And so now we have this increased hazard as it applies to arising out of. And I think that you really only get to this component when there is that level of a pre-existing condition that we're always searching for. Through discovery and depositions and subpoenas and everything else. I think that it's a lot easier for claimant lawyers to understand the arising out of because they have the access to the claimants from day one. We don't have that access. And, so to the extent that there are claims professionals who are talking to these injured workers early on, it's incredibly important that at that moment in time that we develop that evidence immediately so that we understand, is there some level of a pre-existing condition that imposes this next level of a burden of proof on claimant lawyers that we can develop through discovery. I think that the increased hazard component is really fact-specific, right? So one of the claimant lawyers was talking about the appellate standard of review. Is it competent substantial evidence or is it de novo? Is it a factual determination or is it a legal one? And I think it's mixed. And part of it is this analysis, right? Part of it is that an increased hazard, and can the judge rely on that